My office gets a lot of calls on cases where a person who's been involved in an accident has been dealing with the insurance company on their own, and the insurance company will tell them, you're partially at fault for this wreck. You are 40% responsible or 30% responsible, and will not pay them the full value of the case because of that alleged responsibility. So it's often an issue in these cases is who's at fault, and are both parties at fault, and if so, to what extent. In Oklahoma, this is called comparative negligence, and if a jury believes that my client is partially at fault for a wreck by a certain percentage, then they reduce the verdict by that percentage. Insurance companies will often tell claimants or injured people, you're 50% responsible for this wreck, we're not going to pay you anything on the settlement. I've got a case now where the other driver who was at fault ran a red light, but the insurance company said to my client, well, you should have seen him, you could have had a chance to avoid the wreck, we think you're 30% responsible. So this is a tactic they employ a lot, is putting partial fault on the other driver or the injured party. In that particular case, I was able to find a witness who saw the entire wreck and said, your client didn't have a chance to avoid it. They ran the stoplight right in front of them, nothing they could do. So there's lots of situations where an insurance company may blame a victim of a car wreck for being partially at fault. If that's the case, you need an experienced lawyer on your side to investigate the entirety of the accident and make a real, true determination as to who is and is not at fault. So if you've been in a wreck and you're in that situation, call my office and let us help you.